All right, well, good evening, everyone. Today we're going to talk about digital health and the law and focusing in on 3 key issues for vendors to consider in contracts in this space. So as Susie shared, my background is that I am a business tech attorney that focuses on working with software, SaaS, and digital health businesses and AI businesses in making sure they're negotiating and drafting the strongest contracts they can so that they can get investment, they can get acquired, they can just continue to grow. So feel free to reach out to me at any of my website, email, or LinkedIn. So as an initial matter, what are some examples of digital health? So this is a term that we've been hearing a lot, and it can take various forms. So just for example, it could be anything such as a SaaS or a software application in the health space. It could be from everything in hospital systems or more into wellness, something that's less officially actually involving PHI, private health information, protected health information. We then have other things such as wearables that are another form of digital health where they're tracking data and gathering data and all of that. We also have things like telemedicine and health tracking, also health information technology. So it could be like managed service providers for hospital systems that are running their IT. Another concept that comes along with digital health is that a lot of the innovation that's being done in this space is also geared towards, democratizing healthcare more. So one aspect of digital health is, companies trying to focus on how do we make wellness and health something that's more accessible to everyone. So it's very interesting to see the innovation that's going on in the space right now. But with the innovation, of course, there's different challenges. And part of this is you have to obviously enter into agreements when you are a business operating in the space. And these agreements can take a whole host of various forms depending on what your particular service and or product offering is from your business. So a common way it may take shape is a master services agreement. It can also take the form of a master subscription agreement. There's professional services agreements, there's IT managed service agreements, and usually there's more than one agreement at issue. There's a whole host of related agreements that come into play. So when you have a PHI, for example, involved, you're going to have business associate agreements that are required by HIPAA. You're dealing with sensitive data, you're going to have DPAs, data processing addendums in many situations. You will have service level agreements. If you are offering some kind of service, you're going to have acceptable use policies. These are just some of the examples of different types of agreements that you'll run into. So one of the issues that comes off repeatedly in these kind of transactions is intellectual property concerns. This is very important to any business that is operating in not just the digital health space, but the SaaS, software, AI, tech space in general. So one of the first questions is, how do you want to structure the provisions around how you are, allowing people to interact with your intellectual property? And there's a couple concepts about how this is all kind of formulated. One, there is the concept of a license. So for example, this is, and traditionally before we started getting SaaS becoming popular, there was the concept of a software license. So someone would purchase a license, it would live on their local machine, they would have that copy, it was theirs. So that is one form where you're actually licensing something to someone so they can have a copy locally. Then you have the subscription model, which is the SaaS model, right? Everyone is basically purchasing the right to access and use the software through some kind of central, web-based mobile app. The third kind of kind of form of intellectual property is when you have assignment of the IP, right? So in that situation, you are signing over ownership and control of the intellectual property to someone else. This comes up, for example, in software development situations where you're having someone develop software for your business and you want to make sure you own it, or when you are early stage in a business, you're bringing on contractors, for example, you want to make sure they're assigning those intellectual property rights to you so that your business actually owns the IP that's being kind of created. So these are very important concepts to understand and address from the beginning, because intellectual property rights differ based on this structure, right? Under a license, someone's getting a license to use. It could be exclusive or non-exclusive. Non-exclusive means you can license others. Exclusive means you can't license it to anyone else. Subscription, as we talked about, is right to access and use it. And then assignment is going to be that you don't own it anymore. This gets particularly tricky because a lot of times vendors, particularly when they are negotiating with large hospital systems or other large entities, will be faced with a situation where the customer is insisting on using their paper, right? So their agreement to close the deal. So this often takes the form of some kind of services agreement, usually like a master services agreement. However, the issue with this is they're very rarely set up really to deal with a SaaS kind of situation. And they're usually have provisions in there that involve assignment, right? Because it's meant to cover all types of vendors that the hospital or the business, the customer may be interacting with. So they want to own intellectual property that's being created. So it requires a lot of revision to make sure that the agreement actually will work for the SaaS offering that you as a vendor, like a SaaS vendor, the digital health space is actually offering. You don't want to be in a position where you unintentionally have assigned away or given away intellectual property rights because you were so eager to close the deal that you just signed it. You didn't actually take appropriate attention into revising those terms and making sure that you were preserving your right to intellectual property. So one, you have to consider how to structure it, and then make sure if you're not using your own master agreement, which I really recommend businesses invest in setting up, that they have support in negotiating a deal with the hospital system to make sure they're not giving away rights to their IP unintentionally. As part of this, particularly when you are structuring how you are going to structure the IP, you need to think about how the fees will be structured tied to all of this. For example, are you going to charge per user if you do like a license, or a subscription? Is it just unlimited? Like how are you going to structure that? If you do end up creating something which you will be, if you're doing some kind of development work, you are going to give over assignment, you're going to give up ownership. How are you valuing that? Are you setting it at a high enough rate that it makes sense for you to assign over ownership? So those are important things to consider at the start. It's also important to be sure that you're imposing appropriate restrictions on customers in your agreements. So you want to make sure, for example, if you have your subscription agreement, you're going forward as a SaaS, you want to make sure that you are not having situations where clients are going in there and taking, trying to reverse engineer or use it to create their own version of the technology, or creating derivative works of it. Those are all things that you want protected. So you need to have restrictions on all of that and how the customers may use the platform in their agreement. Again, those IP issues are important. You need to establish clear provisions, establishing that you own the IP, that you're only granting them the right to access and use it, and that they're not allowed to use it in ways that are detrimental to your ownership, such as accessing the software to create a competitive product. You also have to consider open source issues depending on the structure of deal. So this often is not a big issue in SaaS, but does come up when businesses start to get creative and they want to close a deal. So I've seen this come up where, a business is working with a larger customer. They're very excited about closing this deal, and the customer is deciding to structure the transaction in a different way. For example, I had a situation where they wanted to use their own virtual machines instead of the business's virtual machines to run the SaaS. And those all create considerations about open source and whether that is a situation where you are distributing the code and it becomes a situation where the open source, you need to understand what open source code is incorporated underlying your proprietary software so that you don't end up unintentionally open sourcing your software, right? There's this thing called copyleft, which there are open source, contractual provisions that have this. It basically means anything that they are attached to becomes open sourced if it is distributed. So you have to be very careful. You should be keeping a repository of what open source you're using in your platforms, in what you're putting together, and make sure you are understanding how that will impact if you decide to get creative in how you're distributing or allowing potential customers to access your SaaS, for example. You then have the additional kind of complexity of when you start to include professional services in your agreements as well. So a lot of clients I work with include both, they can include both the SaaS portion of their offering, but they also have a professional service part of their offering. And so this means that they are actually performing some services too. And this could take the form of everything from implementation, integration, customization, some of that involves development work, and there may be intellectual property created in that process. And again, a lot of customers may try to assert that they own that intellectual property that's being created. But that again creates an issue for a business because a lot of that work is very common among different customers the business may be working in, right? Like the implementation that you may be doing is not going to be that different between different customers, or you may have some similar customization different customers would like. So you don't want to be giving away that intellectual property again. So you have to consider, well, how can I structure this to help protect, make sure I retain the rights, but the customer still has the right to use. And so there are ways to structure that, such as licenses, to help make sure the business remains protected, but the customer also has rights to use it for what they need to use it for. Another request that comes up in the intellectual property world sometimes in these deals is source code escrow requests. So this used to be more of an issue back in the world where it was licenses with traditional software. These days, it really, it occasionally does come up where a customer may ask to have a source code escrow, but it's a big ask. And usually, you try to negotiate out of it because you don't really want to give your source code to someone else, right? That is creating a situation where you now have someone who has potential access to your source code if they can argue that the different elements have been meant to have the escrow turn over to them. So if you do face that request, you do need, make sure you're getting help to negotiate those provisions and see if there's ways to get out of it, because it's definitely not recommended to allow that to go forward. Another kind of complication is government party negotiations. So anytime you're dealing with the government, there are special rules around intellectual property with government deals. So you have to be very careful, again, kind of like the open source issues we were talking about, in how you structure those deals and how you negotiate them to make sure you're not unintentionally giving away intellectual property to the government. So make sure if you are entering into a deal with a government, you have the support to negotiate appropriately to structure their agreement specifically for a government entity versus what you usually do for the commercial entities you're working with. So another area that comes up a lot in these situations for vendors operating in the digital health space is data use and rights. So data use and rights are obviously very important, as a lot of SaaS and software vendors these days particularly are using artificial intelligence in their offerings. And that means that their products and platforms are meant to be adaptive. However, there is kind of a disconnect between the customers here because since there's PHI at issue, all the parties need to consider the applicable provisions of the Health Insurance Portability and Accountability Act of 1996. So it's the HIPAA. This requires a business associate agreement, which is basically an agreement that governs the use of the PHI. And it's something that you as a vendor have to understand that you have obligations that you will have to pass through to vendors and subcontractors too. So you have to be particularly careful about what you're kind of agreeing to on the front end, because you're going to have obligations that you're going to have your vendors agree to as well. The big conflict here is there's a desire by customers to really protect their information and limit the access to it and the use of it by a vendor. However, vendors need use and access to the data to actually allow their platform to work as they have promised, right? If you have promised your platform is going to be adaptive and the AI is going to be getting better, well, that AI requires training to do so. So often it involves having to educate the customer's internal team about why the transaction has to have certain language around data use and data rights. Like I often find I've had to educate in-house legal counsel for hospital systems about this when I'm negotiating against them on behalf of a SaaS vendor, right? They're not really tech attorneys often, so they're not really familiar with why things have to be a certain way, but you have to educate them in that process and get them to understand if we don't have certain language, well, then the AI is not going to work. The adaptiveness is not going to be there. And that's why the hospital is buying this technology. So you have to figure out ways to come up with potential solutions that may be workable for the hospital system. For example, there are ways to come up with some compromise offerings around what scope of data is being used and limitations on monetization by the vendor, right? So for example, perhaps you have heard of the term de-identified data. So that is a term that you hear with any of these data privacy laws. It basically means data that's been anonymized. So as a vendor, you can take the position that any data that you're really using to train your AI and to improve the product will only be that anonymized data that you've anonymized securely, that's not going to be able to be de-anonymized and traced back to individuals. And you are limited to using it to solely improve the data, improve the product. You are in no event going to ever sell this data, right? And coming up with compromise solutions like that often makes the hospital system feel more comfortable and able to move forward with the deal, basically because of that limitation around what data is being used. The important thing with this is also to ensure that there are no conflicts between the master agreement and the business associate agreement that'll go along with it and any other related agreements that may exist. Because a lot of times, multiple of these agreements will address the same issue around data use and data rights. So I've definitely seen very regularly that hospital systems have it both in the master agreement, but also in the business associate agreement. And you want to make sure there's consistency within those, because if you have, for example, you are able to negotiate in the master agreement that, yeah, you can use the data and it's no problem, but then you forget to negotiate it in the business associate agreement. Well, the business associate agreement governs over data security and data privacy issues. So in effect, you don't actually have the right to use it because you forgot to negotiate it in the related agreement. So it's very important to make sure you're negotiating the deals in conjunction and there's consistency between them, so you can actually ensure that your product is continuing to be improved and you can continue to adapt it. So data use and data rights are very important. So another kind of key area is data privacy and cybersecurity, of course. So this is increasing concern with so many deals and businesses, right? We are seeing more and more situations with data breaches. Insurance is getting more expensive, and there's being more exceptions to what is covered. For example, I was working recently with a client who was like a medical practice who had one of their vendors who suffered multiple cyber attacks, and their insurance only covered the data breach portion, not the portion that involved them not being able to operate their business because their whole online system was down and they had to go back to taking handwritten notes and all of that. And so they were not able to really operate their business for several weeks, and their insurance coverage didn't really cover that. So it's important for many businesses realizing the effects that this has on their business, not only from a reputational aspect of having a data breach and having to face the consequences of the penalties that are the statutory kind of penalties and legal liabilities that are associated with that, but also just not being able to operate their business. So one of the ways that businesses operate in this space can try to cut down some of the back and forth that is on these deals is to consider going down the route of getting a SOC 2 audit to streamline negotiations and open up more customer opportunities. So as an initial matter, a lot of customers will not even consider a vendor unless they have a SOC 2 audit in place or some equivalent like high trust or something where they have done some kind of certification for security reasons. Additionally, a lot of times as a vendor, you are presented with a very burdensome and long security document or security policies that really go down into the nitty-gritty about how you're, requiring you to how you're going to encrypt things, how you're going to allow your employees and contractors to have access to things, all these really detailed requirements around cybersecurity and data privacy, which it's not going to be consistent among all your customers, right? So it's going to take a lot of effort to try to negotiate those small points, and just being able to tell a customer, hey, I've done a SOC 2 audit, I can agree to provide that to you on an annual basis. It's a way to make them feel more comfortable and kind of cut out a lot of that back and forth on these nitty gritty. You can just kind of replace it with this. So it's definitely something that can help a business really scale and grow. You also have to really consider the different liabilities and indemnities that are involved in the agreement. So indemnities are basically mean they are a right where, say, for example, one party is, say your customer is called into court and it was because of a data breach that was caused by you. So really they shouldn't have been, pursued. Like the person who sued them should really have sued you because you were the one who committed the data breach. So you are liable to protect them in that situation. And indemnity basically means you'll come in, you'll pay for attorney's fees, you'll pay for damages, you'll defend your customer. And there's also situations where they will do the same for you. If it's something that you were, forced to go into court over a situation that was really their fault. So the most common indemnity in these situations is just an infringement indemnity, right? So as a default, for example, a SaaS vendor in the digital health will say, hey, if someone ends up suing you saying you have infringed their intellectual property because you used our platform, we'll come to court, we'll defend you, we'll pay for the damages because that's not your fault. But even though that's a standard indemnity, customers a lot of time will argue and negotiate for more indemnities, such as, hey, if you have caused a data breach, right? Or you have breached confidentiality and that leads to a claim against us, or you've violated the business associate agreement, then we're entitled to indemnities. Or if you have decided that you're not going to apply with the security provisions you agreed to, right? So there are all these other different indemnities that hospital systems will push for. It's quite common that they will push for indemnities around data breach and the business associate agreement and cybersecurity. So these are things that you should be prepared to negotiate with them and be prepared to see what you're comfortable giving to them. Additionally, consider, if you want to additionally ask for them to potentially provide indemnities to you for their own data breach, or giving you customer or their customers' data that they didn't have authority to give, but they gave to you, right? So there could be some mutual indemnities that you can get there. The other thing to kind of consider here is liability amounts. How much is the deal exposure versus what is the value of the deal, right? Because ultimately you want the upside of the deal to be in line with the downside and not to have the downside to be exponentially different than the upside. Otherwise, it doesn't really make sense for you to go forward with the deal, right? So often customers will ask vendors for uncapped liability for a lot of these key issues. Uncapped liability means there is no limit to how much you will be liable to pay for if a lawsuit arises or a claim arises. This means, if there's a data breach and, and keep in mind a data breach is likely to affect more than one of your customers if you suffer a data breach. So if you are giving uncapped liability to just one customer, you can be out of business, right? So you need to consider what may make sense. So one thing that a lot of businesses consider is doing a secondary, what's called a secondary cap. So in general, you put some kind of maximum amount on the amount of liability that each business will be exposed to for most claims, and then you have exceptions from that. And instead of having exceptions that are unlimited, you start to negotiate a secondary limit to those exceptions. So while the first exception may be some number of fees, you may go for the second cap and say, hey, we'll go to a max of $1 million, whatever the number is that makes sense for that particular deal. So you still have some kind of cap of maximum damages that you're going to be liable for that makes sense for you as a business decision based on the value of the deal and the upside you're getting from that. But it's something to consider carefully. These indemnities and liabilities are both heavily negotiated again, along with the security provisions themselves. The other kind of related item that often comes up with this is that because you're in the digital health space and HIPAA applies, there are, breach notification rules and all of that. So hospital systems will also often request reimbursement for data breach notification and compliance related costs. And this will often come up in the business associate agreement, so separate from the MSA. So again, you need to closely review and negotiate these documents in conjunction, right? Yeah, you may have indemnities and limitations of liability addressed in the MSA, and then you have the separate obligation in the business associate agreement. You want to make sure if you're agreeing to that, are you wanting it to be subject to that limitation of liability? You need to tie the two provisions together between the two agreements. So again, it's important to make sure you're connecting all the provisions between these two agreements so that you're not unintentionally agreeing to greater liability than you thought you were, or greater responsibility for reimbursement or damages in situations which you thought would not be the case. Something kind of related to this is making sure you have appropriate insurance policies in place from the start. So customers will also ask for insurance. There will be agreement provisions asking for insurance in all of these agreements, and they will have various types of insurance from general liability to errors and omissions, and cybersecurity liability. So if you are a vendor who is operating in this space, you need to be getting insurance from day one, and you need to be getting it at appropriate rates to make sure that you're able to be covered when a customer requests to include the insurance amounts in their agreement, and they often ask to see a copy, be provided a certificate of insurance, which is, like proving that you have the insurance. They will also make additional requests relating to, being added on as a potential insured on your insurance policy. So there are different things that may come up, like they will also often ask waiver of subrogation. So these are items to discuss with your insurer too, to understand if there is additional, like one, is it possible to do these things? Will it involve additional cost? So that you can decide, is this something that I'm comfortable giving to a customer when they make a request, or do I need to continue to really negotiate to get out of this? And so pay attention to the insurance, because it can really help you close a deal. The other item related to this is that you need to really vet your vendors and subcontractors for all these same issues around data privacy, cybersecurity, indemnity and liabilities, reimbursement. All of this is very important to vet with your vendors and subcontractors and hosting providers, particularly when you have pass-through obligations. So often hospital systems and customers will try to force you to actually have these provisions explicitly in every single one of your agreements with vendors and subcontractors. That's that's a kind of burdensome requirement. So it's it's I always try to negotiate out of that explicit requirement if I can, because it's pretty burdensome. But you still, regardless if you have an explicit requirement or not, you still need to be passing on these similar provisions to your vendors and subcontractors. One, because HIPAA requires you to pass some of this on, right? You have to, if you're sharing PHI with them, you have to enter into a business associate agreement with them. But also, you are going to be on hook for what they do. So if your vendor has a data breach of your customer's information, well, you're going to be on the hook to your customer. So you want to make sure that you have the appropriate indemnity from your vendor, right? So that you're not being put out of business because you didn't have coverage from them for their breach, right? You want to make sure they have the right liability, so that, again, if they've caused a breach for your customers, they're going to cover that for you. So it's important to think about these issues when you are working with various vendors that support your tech stack. It's similarly important to consider whether they have a SOC 2 audit in place, right? Because again, you want to make sure they have the right security to limit your risks, right? So you start having to look at all these issues with your vendors. I think it's important for businesses operating in the digital health space to understand that data is really, it's like a chain, right? Data is coming into your business and then it's going out of your business to vendors. So you need to be protected on both sides of that equation. You need to negotiate the right agreements and provisions around data privacy and cybersecurity with your customers, but also with your vendors to really best protect yourself, to be set up from a place where you can scale and grow. I think businesses also need to be cognizant that all of this becomes more complicated when you start doing, potential partnerships or alliances or ventures with other potential startups or collaborators. All of these issues become more complicated. For example, IP becomes very complicated. I've seen situations where, startups in the space want to create a joint offering, for example, right? Well, you need to know who's going to own the intellectual property in that joint offering. So you have to negotiate very clearly to make sure you are both retaining your ownership and not giving away more than you intend, and also having rights into what is the new IP that's being created. Similarly, you have to address the same issues around data again, right? If there's data coming in, how are you, how's this data flowing? Who's getting to access it? What kind of access? What kind of data? So these are all complexities that come into any of these transactions that you may be engaging with. Another kind of situation that comes up that I often see is you may bring on a software development company to help you build out some additional related features that a particular customer, some customers are requiring, and you want to kind of beta test it. So these are, again, important, where you have to make sure that you are getting the IP assigned to you, right? You want to own this because it's something that you want to be able to use over and over, but you also want to make sure they are having the right, data privacy and cybersecurity issues in place. Because if this, it's a smaller vendor, but if they have a breach, you're going to be on the hook for them. So very important where they have access to your whole kind of data stream and all your database.